Hello, and welcome to today's webinar. My name is Daniel Castro, and I'm Director of the Center for Data Innovation. The Center is a think tank focused on the intersection of data, technology, and public policy. And today I'm delighted to host a new author in our book talk series. For this session, we're privileged to be joined by Ryan Abbott. Dr. Abbott's a professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the UCLA School of Medicine. He's also the author of the recently published book, The Reasonable Robot, Artificial Intelligence and the Law. Dr. Abbott, first of all, thanks for being here. Really excited for this conversation. Your book, argues as a general principle. I'm going to apologize in advance because this is a gross oversimplification of what you say, and I hope you go into much more detail in your talk today. But as a general principle, you argue that the law should not discriminate between AI and human behavior. And you go through how this principle could, apply in different areas of the law, including tax, tort, intellectual property law, and criminal law. For everyone joining us today, this program's meant to be interactive, and your questions and comments are most welcome. So if you're watching online, you're invited to submit questions via Slido. If you're watching on the center's website, you can see the link at the bottom of the page to Slido where you can submit the questions. If you're watching on YouTube or Facebook, you should see the link underneath the video description. So Ryan, thanks again for spending some time with us today and sharing your thoughts on your very important book. The floor is yours.
Well, thanks, Daniel. It's a real pleasure and honor to be here, and thanks for everyone for tuning into this. I do apologize that my internet seems to have been struggling a bit for the past day for no particular reason. So if I freeze a little bit, this just goes to show the imperfection of human beings and why it's important that we consider letting AI do a few more of the tasks we've grown accustomed to. This book is looking at a phenomenon of machines stepping into the shoes of people and doing the sorts of things that only people used to do. Or if AI had been doing that before, it had been doing it in sort of a toy problem sort of way, where it was an academic phenomenon. But AI is getting better and cheaper and faster at doing human-like sorts of tasks, and already increasingly automating functions, and AI will be automating much more in the coming years. And the book looks at a variety of ways in which this happens and how the legal system distinguishes between behavior being done by a machine and behavior being done by a person, and how somewhat counterintuitively, when the law draws distinctions like this, it tends to have negative social outcomes. And so the book argues that we should be applying as one of many principles of AI regulation, like transparency and fairness and accountability, AI legal neutrality. The idea that we would get better social outcomes if we did less to legally discriminate between AI and human behavior. Now, that isn't to say an AI and a person would have exactly the same rights, or that an AI would have rights at all. An AI can behave like a person, but an AI is not like a person. It doesn't morally deserve rights. And yet, rights for artificial persons, largely in the form of corporations and governments, is not an unusual thing. We do grant rights to artificial persons, but we do so because we think that this produces good social outcomes. So corporations can enter into contracts and hold assets because we think that sort of thing encourages commerce and entrepreneurship. So it isn't necessarily the case that it would never make sense to treat an AI like it had some rights or obligations. For example, if you had a self-driving car and it was really autonomous and it needed to hold an insurance policy to potentially compensate victims, but you wouldn't protect an AI like that because it was morally deserving of rights, which is why the book really focuses on behavior. So I think the best way to see how this principle applies is to hop into a few different areas. And you'll be happy to know that we're talking about taxes and patents in this lecture, which are pretty much the two sexiest areas of the law. And I'd like to start with the sexiest, which is tax policy, and how that fits into automation policy in the future of work. So discussions about AI and automation are nothing new. They've really waxed and waned in public consciousness, but been a substantial feature at several points, including as far back as the first industrial revolution in England, where people worried that machines were going to take everyone's jobs and people would be left out of work. Didn't turn out to have happened that way. For example, if you look at agriculture, at the turn of the 19th century, about 40% of the workforce was in agriculture, and now it's about 3%, and we don't have 37% unemployment. Agriculture has gotten more productive, people have gone on to find new types of work, and really everything has worked out for the best. Although for the people who were put out of work, they have certainly suffered some individual harm, and we perhaps haven't done that well as a society in transitioning people to new job types. And moving forward, it's not entirely clear whether or not history is going to repeat itself. There's a whole lot of jobs that machines are going to take over, but it may well be that the people rendered technologically unemployed go on to find new types of work, or it may be that there's fewer and fewer limits to what machines can do, where the same is not true of people. And so in the future, we may get a scenario where you have machines really automating vast segments of the workforce and people left out of work. Either way, the role of tax in this process hasn't been very clearly worked out, because tax plays at least two major function or the automation debate. One is that businesses are taxed differently depending on whether they have a person or a machine do the same sort of work. So for example, we've become accustomed to going into McDonald's and seeing an automatic teller or an automatic cash register take our order. If McDonald's has a machine doing basically the same job as a person, they don't have to pay payroll taxes for the machine. And so essentially, even if a machine and a person do about an equally good job, and even if they cost about the same amount of money, McDonald's can realize a substantial tax savings by automating. On top of that, there's a variety of other tax benefits they get. For example, accelerating deductions and avoiding incidental taxes associated with employment that the book describes in detail and that you probably aren't that interested in. But the net of this is that even though a machine and a person are doing the same thing, we tax them differently. And this drives businesses to automate. The other major tax challenge associated with automation is that robots don't pay taxes, which sounds kind of ridiculous, but it's less ridiculous if you realize that about 90% of federal tax revenue comes in one way or another from labor taxes. Payroll taxes make up a large portion of it, and income taxes, which are based largely also on labor taxes, also make up a large portion of it. A relatively small amount, less than 10%, comes from corporate taxes. And so if McDonald's automates and substitutes a machine in for a human cashier, not only do we lose the payroll taxes and the income taxes associated with that worker, but even if McDonald's becomes more profitable, a relatively small amount of that profit is remitted in taxes compared to what the person would have paid. So tax policies are not only inefficiently subsidizing automation, they are also reducing tax revenue. And that's a major problem if the solution to the automation problem is that we are going to retrain people in new job types and help provide enhanced social benefits. Or that if we end up with a lot of people just permanently out of work, we're going to provide more social benefits. That's going to be hard to do if we lack adequate tax revenue. So how might the law respond to something like this? Well, I argue that it makes sense to have a more legal neutral tax system between people and machines. And one way you might do that is by having robots pay taxes. Now, that solution has a few drawbacks. It's hard to say what a robot is. Robots may not replace people on a one-to-one basis. There would be a lot of administrative burden, and there would be a lot of gamesmanship with trying to avoid paying taxes for machines doing things. A better sort of way of achieving neutrality might be reducing the taxes that human workers pay. So getting rid of something like payroll taxes, which would end the taxation of something socially valuable, namely labor. And it would mean that when businesses decide whether or not to automate, and I certainly don't think they should be discouraged from automating generally, they do so for non-tax reasons. They do so other than to avoid paying less in taxes. Now that would dramatically reduce tax revenue, and together with automation anyway, that's something we're going to have to make up. And this may be where we take a step back and kind of reconsider how we've been taxing labor versus capital and workers versus businesses. Because traditionally we've taxed labor because we think that labor basically has to work in the United States, whereas capital may go to other jurisdictions if we tax it too highly, or if we tax too much, people may just not even invest. But there's already a large body of critical scholarship about this, because really there's a lot of reasons to invest in the United States. People are not rushing to invest in businesses in the Cayman Islands, even though they have a 0% tax rate. We have a well-developed infrastructure and workforce and human resources and the world's largest market as a country that make investing in here attractive. And so it may make sense as automation is doing more, as the capital is becoming the labor, that we have a more neutral system before labor taxes and capital taxes. And this will also help with distribution, because automation is going to result in a lot of wealth, but it is going to be a lot of narrowly controlled wealth, perhaps at the expense of many people. And so a more neutral and fairer tax system would help to spread the benefits of automation. Of course, robots and AI aren't just working as cash machines or cashiers. They're doing all sorts of things that people used to do, like driving cars. And it's hard to say exactly when this is going to happen. Many companies have predicted we'd have self-driving cars all over the place before 2020, like Tesla. That proved to be a bit optimistic, in part because the last little bit of this is proving challenging to with bad drivers and unexpected circumstances. But AI is close to as good as a human driver, and in the near future, probably going to be much better. You know, part of the problem is we shouldn't be comparing AI drivers against the absence of AI drivers. We should be comparing AI drivers against human drivers. And the unfortunate fact, which anyone who has driven with another person can attest to, is that people are not very good drivers. Human error accounts for about 94% of auto accidents. And so the question is really less, well, are AI drivers going to cause accidents? The answer to that is clearly yes. The question is really, are AI drivers going to cause fewer accidents than human drivers? And I think the answer to that is very clearly going to be yes also. And that brings us to tort law, which is the law that governs accidents largely. And when you have a machine driving a car and a human Uber driver largely doing the same thing, they are again held to different legal standards. So the Uber driver is largely held to negligence law, which says if a reasonable person would have caused the same accident, you won't be liable. And if a reasonable person would not have caused the same accident, you will not be liable for it. Whereas self-driving cars, because they are commercial products, are held to a strict product liability standard, and that's a higher standard of liability. It essentially asks whether, if there's a design defect or advertising issues, a machine would have, caused an accident or not, and regardless of the presence of reasonable care, the machine is liable. Well, as a general matter, having strict liability for products makes a whole lot of sense because we want safe products and we want manufacturers to be liable for it. But with machines doing these same sorts of activities, that same standard may not make sense. It doesn't make sense to have a higher liability standard if you have a technology that is going to be safer than the alternative. And because then you are holding AI to a higher liability standard, it discourages the use of AI, even if it may be safer than a person. And so I think, again, the solution here is that we hold both to a negligence standard. We say, well, would a reasonable human driver have caused that accident? And if so, the AI wouldn't be liable. And if not, then it would be. And this has an additional benefit because it is going to be difficult and very expensive to figure out why a self-driving car caused an accident. And for all but very significant accidents, probably not cost effective to figure out why. Well, if you focus on negligence, you can just focus on the AI's behavior. Did it run a red light? Not why did it run a red light? And if it's something a reasonable driver would not have done, then you will have liability. Ultimately, though, I think in some sense, the liability standard you apply to AI is less important than the liability standard you apply to people, because there are a lot of reasons for AI to get safer, not including just that Tesla wants to advertise that its AI is very safe and prevent accidents independent of tort liability. And AI has the ability to get safer and safer and safer, and human drivers don't. And so it may well be the case in not too many years that AI drivers almost never cause accidents, and by then the biggest danger on the road is people. And it makes a lot less difference there what sort of standard we hold AI to, and a lot more difference what standard we hold people to. And so at the point where self-driving cars become standard, I think it makes sense to hold people to the standard of a reasonable AI or a reasonable robot if you want to be catchy about it. In other words, we'd say, A child has jumped in front of your car and you accidentally hit the child. Well, would a reasonable self-driving car have caused that accident? And if the answer is yes, you wouldn't be liable. And if the answer is no, then you would have been liable. And that would be the case even if the AI would have avoided the car because it could have seen the child, through buildings using radar, and it has ultra fast decision making and superhuman sensors. And that would be a fair thing to do because at the point where self-driving cars are standard, where an AI can do a better job of you practically, but you choose to do something yourself, it would internalize the cost of accidents on someone choosing to behave a certain way. And so even though I may not be able to drive as safely as a self-driving car, right? I have the option to use it. And if I choose not to, I'm liable for it. Another option could be to say, we're just not going to let people on the road when we have very safe self-driving cars, but that would limit human freedom and autonomy in concerning ways. And so this would be a tort-based mechanism for allowing people to decide to drive, but holding them liable for accidents that they unnecessarily cause. And this isn't just going to be in self-driving cars, although I think that's the disruptive example that's coming up in a major way. This is going to be in all sorts of areas, from practicing as a doctor to practicing as a lawyer. Right now, surgical robots are mainly just sophisticated tools used by human doctors. But I think in 10 years, or 20 years, it's not going to be unusual to have a surgical robot that could effectively do the same procedure as a human doctor. And it may well be that we have good evidence that when the machine does it, you have a higher success rate, fewer complications, and faster recovery times. And at that point, it may not even be ethical for human doctors to do those surgeries if they're going to do a less good job doing it. And and that was the end of the statement I had about that. But not only are machines going to be driving cars, working as doctors, and working as lawyers, they're going to be working as creatives. And this is something that people have been working on and talking about for many decades. But it has moved from people having machines create things as sort of a novelty to machines creating things that have become commercially relevant. So, for example, the Washington Post uses an AI called Heliograph, which now writes short articles for the Washington Post, and people are often unable to distinguish between the two. Again, AI has been making movies and music and articles for a long time, and even writing whole books, but they've historically been pretty terrible. And now they're getting to the point where they're not terrible, and they're very fast and cheap to produce. And a couple of years ago, Christie's sold the first painting that was AI generated at auction for about $500,000. And so I think we are just beginning to get into the area of these works having commercial value. But as with tax and as with torts and intellectual property, you have two different bodies of law that apply to works made by machines and works made by people. In copyright law, the existence of copyright generally requires the existence of a human author. But now with AI making things, you may not have a human author. So this begs several questions like, well, can I get copyright for this painting that is sold for $500,000, or can anyone be copying it? Or this copyright for these Washington Post articles, or can the New York Times just pick them up and use them wholesale? If an AI was functionally working as an author, who or what would be credited or listed as the author of something, and then who or what would be the owner of that copyright. In the United States, we have a corporate work for hire doctrine. And so if I work for Google and write an article for them, or I work for the Washington Post and write an article for them, the Washington Post may legally be deemed the author and may have the copyright ownership of this creation, and I may not. But right now in the United States, we don't allow something like that for AI generated works. That's based on a copyright policy since at least the 1970s, but probably actually earlier. And it's based on the case, the 1886 case of Burrough-Giles v. Cerrone. That was the first case that held you could have copyright in a photograph, and it involved this photo of Oscar Wilde, where the Burrough-Giles lithographic company started using the photograph without permission and said, you can't own copyright in a photograph. It's just a natural reproduction. It's an artificial reproduction of a natural phenomenon. And the Supreme Court held no, really any expression by which, ideas in the mind of the author are given expression is eligible for protection. And the Copyright Office is citing to this case and saying that, well, machines can't think, don't have minds, and therefore can't be authors, and neither can monkeys. I'm leading a group that is advancing a legal test case right now for 2 inventions made by an artificial intelligence. So this artificial intelligence, nicknamed Dabus or Dabus, is an artificial neural network. And in the 1990s, there were basically 2 neural networks. One was trained on data, which alters connection weights between neurons to store the data. And then the machine automatically alters these connection weights and it starts outputting data that it has never seen before. So new data. A second neural network monitors what's coming out of the first one and evaluates it for some predetermined criteria for novelty or usefulness. And so this can, among other things, sort of optimize for problems like, designing an Oral-B cross-action toothbrush. Well, today there are hundreds or thousands of neural networks working together like this, each neural network encoding for a concept, and it is trained in combining basic concepts and then goes on to combine to more complex ones. So in 2 instances, though it wasn't given specific direction on what to invent, it came up with a beverage container based on fractal geometry like a snail shell, and a flashing light that could attract human attention in an emergency situation. And in both of these instances, the person who created the machine hadn't thought of these things and was surprised by the outcome. This is not the only case of this occurring. Siemens has recently started discussing that they have an AI that made a new part for a car. The engineers thought it was surprising and interesting and useful, and Siemens wanted to file for a patent on it, but none of the engineers were willing to put their name to it because they had said that the AI did all of the inventive work and they didn't do anything. And incidentally, falsely reporting yourself as a patent inventor in the United States is a crime. So we filed these patents in the UK and in Europe because they examined them and essentially found them to be patentable. And then we announced that the AI had invented it, and now it has been rejected from the US, the UK, and in Europe, although all of these rejections are under appeal, and it's pending in about a dozen more jurisdictions. And again, if you lack a traditional human inventor, it is, well, under these cases, perhaps the case that you can't protect something like that. And if you could protect it, it's not clear who or what the inventor would be because there's no inventor who traditionally qualifies as an inventor, and it's not clear who or what would own it. Well, I'll stay on this page for a second. Historically, some academics have said, well, you don't need patents for these sorts of things because, of course, machines don't care about patents, and the idea of giving a machine credit as an inventor is just ridiculous. Well, those two things are true, but the people who make, use, and build artificial intelligence care about patents. And if what we want out of the patent system is encouraging innovation so that we as a society have more inventions, then one way to do that is by allowing for patents on the output of AI, because that will encourage people to make, use, and build AI that can be used in research and development, sometimes to automate the inventive process. And it's particularly important because in 10 or 20 years, you may have some problems where the standard way of solving a problem is going to an AI, right? So Novartis may go to Microsoft and say, here's COVID-19. We know what it looks like. You have an antibody library of 1 billion possible antibodies. The AI can screen all of those antibodies against COVID-19 and say, this is the antibody that is likely to be most effective. Here's how you design the clinical trials to test it. And this could substantially speed up the whole R&D approval process. But that's going to be a major problem in some areas like life sciences, which really depend on patents. If you can't have a patent with a machine doing the same thing that a human could get a patent for doing, companies are just not going to want to use machines there. We listed the AI as the inventor on those patents, and we didn't do it to give the AI credit. The AI, of course, doesn't care whether it gets credit or not, or whether you unplug it. But we did it both to inform the public of how the invention was generated, and because we want to keep someone from claiming credit for work they haven't done. So if I can own Dabus or one of DeepMind's AIs or IBM's Watson and have it just invent 10,000 things for me, it would really change what it means to be an inventor. And I think it would devalue people who are legitimately working as inventors. Again, you wouldn't have an AI own a patent. No one's suggesting that that happens. It couldn't because legally it can't hold property, but even if it could, it wouldn't care if it got a patent and it wouldn't know how to enforce it. Our argument is that the AI's owner should own any patents on its output, and that is consistent with general doctrines of property ownership. AI is going to change IP in all sorts of exciting ways, and one of these is the primary standard with which we use to grant patent protection. Kind of like the reasonable person in tort law, judges in patent cases come up with this idea of a person having ordinary skill in the art. And basically, this hypothetical person represents an average researcher. If an average researcher would have found your patent application obvious, it can't get a patent. And if it would have been non-obvious, it can get a patent, although there's also several other criteria you have to meet. I chose a picture of London commuters to represent the average worker. This is as happy as they ever look. It's really very cold and crowded in London some of the time. Well, AI is going to change an average researcher because it's no longer just an average researcher, but an average researcher using AI as a tool. And even as a tool, AI makes average researchers more knowledgeable because instead of just knowing what they know, they can have access to a superhuman amount of literature that isn't even in their field. But if they're looking for a solution to developing a COVID vaccine, even chemical compositions in engineering or oil extraction might be relevant. And we wouldn't expect a pharmacologic researcher to know that sort of thing, but an AI really wouldn't have any trouble going into other disciplines. It will also make average researchers more sophisticated by giving them new problem-solving techniques like pattern recognition and big data. And so even now, we may need to change the standard. And in the future, we may need to change it to having a person skilled in the art to having a machine skilled in the art, which I think would be the case if, again, you had a particular sort of problem where the standard solution or way of solving the problem was to ask an AI, right? So if in finding a new antibody to a known pathogen, we no longer went to human research teams, we go to an AI and ask it to solve a problem. And that's not happening now. But again, in 20 years, it may be happening, or maybe a little less time, or maybe a little more time. If you believe in this concept that AI is going to continually improve, and at some point will turn into something we call artificial general intelligence, which refers to an AI that would be capable of doing really anything a person could do, that makes them a natural substitute for the skilled person. And the first thing you'd probably tell an artificial general intelligence to do is to improve itself. And before long, you'd have artificial superintelligence, which would do anything a person could do, only incomprehensibly better than we could do it. And at that point, it's going to generate the solution to really all of the problems we knew we had, and even all the problems we didn't know we had. And we'll get to spend the rest of our days living in virtual reality, but I digress. A final area I wanted to talk about a bit was criminal law, because there are some areas of the law where the law is really focused on utilitarian outcomes or consequentialist outcomes. So in tort law, promoting safety; in intellectual property law, generating creative and innovative works; in tax law, encouraging certain sorts of commercial activities and distributing wealth. Criminal law, of all the sorts of law, seems to be a bit different than that. In particular, we care not only about prohibiting antisocial behavior, but we care a lot about why people did certain things. So even though if I hit you with my car, that might be a tort, if I had a wrongful mental state, like I meant to run you over, or at least I was entirely indifferent to running you over, that sort of thing might be a crime. Well, as you have machines stepping into the shoes of people and behaving like people, it's not hard to imagine that we will have machines functionally committing the sorts of things we think of as crimes. In fact, we've already had some of this. I mean, largely it is, again, just machines acting as tools. So if I pick up a computer and hit you with it, that's me committing a battery, not the computer. But in the future, as machines get increasingly autonomous and it's harder and harder to reduce machine behavior to a particular human act, we will be likely to have machines that are functionally committing crimes. And it's not entirely clear whether it makes any sense to think about a machine committing a crime, because in some sense, they're just executing programming. They don't really have a mental state. And culpability and retribution are really fundamental to criminal law. So we care about someone behaving in ways that are morally wrong, and we care about punishing people because it's the right thing to do, not just because it produces the right social outcomes. And it's a lot more challenging to fit machines into this mold. I mean, on the other hand, it is not like robot taxes so crazy a thing to think about, particularly because we already hold corporations liable for committing crimes, even though obviously, literally, a corporation doesn't have a mental state. There we impute the mental states of a corporation's agents to it. And some people even question whether on that basis, whether we really need corporate criminal liability at all. I mean, in that view, there's always someone at a company who has done some bad thing. And ultimately, punishing a company is punishing often innocent shareholders. And so maybe it doesn't make sense to have that at all. On the other hand, there's also schools of thought that hold that really companies do have some sort of existence above and beyond the individual agents, that groupthink and different layers of activity really result in behavior and thinking that isn't attributable to an individual person. Well, it's going to be a lot harder to attribute a machine act to a person act as machines become increasingly autonomous, as training gets more complex, as thousands of programmers in open source contributing over space and time contribute to something. And what would it look like to think through maybe punishing an AI? Well, that could have some benefits. It could have some benefits, if it, to the extent it could impact AI owners, users, and developers again. Once more, we're not trying to influence an AI behavior. We're influencing the behavior of the people who make AI. If, for example, we were confiscating valuable AI or destroying it for committing a crime, and that would encourage people to make AI that wouldn't be confiscated or destroyed. It could also have expressive benefits in saying to someone, if there's a self-driving car that's deliberately running over investment bankers, we're going to convict this car of a crime and say as a society, we're not going to tolerate this behavior, whether it comes from a person or a machine or anything, right? On the other hand, there would also be costs with doing this, particularly because this isn't yet a significant social issue. There would be a lot of cost to changing the law to holding a machine liable for something. It could undermine the rule of law and the rationale behind law, and it could also send a troubling message that machines are on par with human beings. So punishing machine probably isn't a good idea, but it isn't necessarily so inconsistent with criminal law doctrine, given that we already punish corporations. We already punish corporations for strict liability offenses, which is to say offenses without a mental state. And sometimes where there's a duty to act, you can punish an artificial person based on a failure to act, even without an adverse mental state. So those are a few different areas in which people are stepping into the shoes of machine, how the law treats people and robots a bit differently, and how, as a general matter, this tends to produce unwanted and negative outcomes, and how if we change the law to be more agnostic between people and machines, we'd get better social outcomes and we would help the law to better achieve its underlying goals. And today, this may not be, in some cases, the most important thing to be worried about, but it may be very soon. And I think it's helpful to look at how machines have done with board games, which, again, aren't that practical of an endeavor, but are one of the earliest tests of machine intelligence, and I think give us a hint about how AI might perform in the future. In 2007, an AI beat the world's grandmaster at the board game Go, and some experts had thought this would take another decade. Go is the most complex traditional board game. AI can now beat people at any traditional board game that exists. There's now an entire field of human activity in which AI dramatically performs better, cheaper, and faster than people. And again, board games aren't that practical, but it remains to be seen how quickly and to what extent AI will do this in other fields of activity. Now, when Deep Blue, an IBM machine, beat Garry Kasparov in 1998, and after he regained his composure, he had a bright idea. He thought, okay, so a machine can always beat a person, but I think that you might get an optimal mix of activity by having a person work with a machine. Because human grandmasters are very good at thinking very far out at chess, and machines were not so good. but machines were good at calculating 300 million potential moves in a few seconds, and human grandmasters weren't so great at that. And sure enough, Kasparov was right. The next year, he placed first in the first human AI Centaur chess tournament, where a person played with a machine. And indeed, the near future may be one of augmentation, where people and machines have overlapping skill sets, and you get a best mix of activity by having them perform together. But also in 2017, the year that Alphabet's DeepMind AI beat the world Go champion, the chess engine Cryptic beat the world's best human plus AI team. And so in the long term, people may just get in the way. Thank you.
Thanks so much for that overview, Ryan. I think there's a couple of great things about your book. One is that, first of all, you cover a lot of ground and cover a lot of issues. The second, even though I don't agree with everything you write in the book, what I really like about your book is you lay out concrete positions on all of these issues. I think I've read too many books where somebody says, well, these are issues we need to be thinking about over the next 15 to 20 years. I'm just raising the questions. We need to search for solutions. What I really like about your book is you really take clear positions on each of these areas, which I think gives a lot of opportunity for thought, for discussion, and it just makes for a really interesting read. So thanks for the presentation. Thanks for the book. We have a lot of questions coming in. I'm going to take moderator privilege to ask a few of my own first, and then we'll start pulling in from the audience. Again, if you're joining us online and you missed the very beginning, you have an opportunity to ask questions using Slido. The link is on the website if you're watching on datainnovation.org. If you're watching on YouTube or Facebook, just look for the link in the video description. So one of the first areas I want you to maybe expand a little bit on, I really thought your discussion about, you raised some really interesting points around tort law. And you talked about how if you have the strict liability standard for AI, that might actually end up decreasing consumer safety because you'd be limiting deployment of AI that's safer than humans. And so I thought that was a great point. But I guess my question is, does that reflect a broader problem with strict liability in general, or why is this unique to AI products? If and not just all products where maybe it's better to use this product than have a human do something.
Well, I think as a general matter, product liability probably has it right with strict liability in the sense that, manufacturers are much better situated than consumers to figure out, the optimal mix of safety of their products because, it is hard and sometimes cost prohibitive or impossible to have absolutely safe products. And we do want a higher standard of liability. The difference here is that, again, we're not comparing some new product to nothing. We're comparing it to really a very concrete substitute. And if the question is, well, should we be substituting this new product? I think it also pretty clear that what we are going for is not some absolute level of safety, but we want something that's safer than the substitute, because then we start getting safety benefits with that. But not only is that the case really where I think you have any mix of human and AI activity where you either have a human standard or an AI standard and they are somewhat interchangeable. I do think kind of the more exciting and relevant bit of that is these cars are just going to improve for non-tort reasons and a whole lot of non-tort reasons. And, people are going to end up being held against that standard. The other things I like about the standard are that it reduces these challenges of complexity and opacity and transparency with, black box algorithms. I think the focus should really be on, at least in safety areas, outcomes. So it could be a little problematic if we don't know why a self-driving car is making certain decisions. But I think it is more important to see, well, does the car have better outcomes than an explainable AI or a person? And by focusing on the behavior rather than what's going on inside the AI, we're focused on the right issues from a tort perspective.
I think that's really important. And, that's a difference, of course, we see between how Europe's approaching these AI issues and how the US has generally been approaching it, where the EU's had this really strong focus on explainability. Do you see a difference in the European approach to the tort issues as well?
Yes, I do. I mean, I think it's a bit more conservative, and explainability, I think, really has to be very context dependent. So, for example, some of the more controversial uses of AI have been in criminal sentencing decisions. And I think there it is really critical to have an explainable AI. And I think part of the reason for that is it's not clear that there is a right answer to whether or not someone should, say, be allowed to post bail. And so we need judges and bystanders to see, well, why is the AI coming to the conclusions it's coming to? On the other hand, with something like a self-driving car, or sometimes even with the practice of medicine, I absolutely know what the right outcome is. You get me from point A to point B and you don't hit anybody. And so in some sense, I really don't care how you get me from point A to point B if you can demonstrate that you're doing so safely. And if you have a machine that can explain, well, here's why I hit the person, that's of a lot less use to me. There is some fascination with the trolley problem with self-driving cars. So when you have to program an AI to decide if it's going to hit an older person or a younger person or two people or one person, although everyone's pretty much on board with hitting one person over two people, the rest of it is hard to stipulate to an agree to up front. But, I think one of the nice things about self-driving cars is, it's going to get rid of the trolley problem because it is going to just prevent the need to hit one or two people. It's just going to hit up the brakes faster than a person would.
Yeah. So as you mentioned, obviously the title of the book, The Reasonable Robot, there's this idea that you said at some point, people might be held to the standard of the reasonable robot. Can you talk a little bit more about kind of how you would create that standard? So in any market, any marketplace, you have varying levels of performance. How would you define, I think on the reasonable human, there's already questions about that, but on the reasonable robot side, how would you define, what that standard should be when, there's obviously going to be different price points, different functionalities, and it will be changing over time.
Right. No, a great question. And I think it is fairly context specific. With cars, we don't insist that everyone has a $100,000 car with all the most advanced safety features on the car. But we do have some minimum requirements for people having, functional brakes on their car. And so, in a similar context, we couldn't hold people to a reasonable robot standard if, only Tesla was making self-driving cars and they all cost $100,000 and Tesla could only make so many of them. I mean, these would have to be technologies that were widely available, where it was practical to automate, and when they had, in some sense, become, often but not necessarily the standard way that people get around. And I don't think there is, necessarily a line in the sand one can draw about when that comes in. The book goes through several factors I think a court would have to consider in making a decision like that. But I think as a general principle, right, widespread availability and affordability of these new technologies.
Yeah, I mean, we certainly see, globally, cars are cheaper in certain countries because they don't require airbags, right? I mean, we've seen that kind of variation. Do you think there will be kind of global standards in this space?
I do think there'll probably be global standards. I mean, I expect that, like many new technologies, they are going to be expensive and only available in developed countries first and at a particularly high price point, but that they are going to get driven down in price. And I think that, in developed countries, at least, it is just going to make very clear sense for people to be automating, to be providing accidents. It will be unfortunate, I think, if you get a bit of a developed world divide over the fact you couldn't afford these kind of vehicles in developing countries. And that is something that I think we should be working on, kind of aside from AI legal neutrality, from a technology transfer and international trade perspective.
Yeah. So just kind of maybe switching gears a little bit, you if I understood correctly, you kind of come down on the side of opposing punishing AI in a criminal sense, right, for causing harm to people or I guess to society. So I was curious though about where you stand on humans causing harm to AI systems, because you noted that there was this proposal to you maybe want to have a limits on cruelty towards robots, that there could be a reason to do that. So I was very curious how you came down on this issue, because if you applied your equality standard, it would seem like, well, if you if you're not going to punish the robots for causing harm to humans, you don't want to punish the humans for causing harm to robots. But I don't think that's where you come down. So I was curious if you could kind of expand on that.
No, that's a great question. It's not something that I've written or thought about too much. Kate Darling has written on this, and I can't remember the other person who presented at We Robot I cited who'd presented on it also. Kate Darling made the fair point. For example, in the UK, there's a Cruelty Against Animals Act, but it is not an act that prohibits cruelty against animals on the basis of animals having rights. It is a law that prevents cruelty against animals on the basis that it is demeaning to human beings to be cruel to animals. I think, my personal view is that animals do have rights, even if they are different than human rights, and that there are probably two good reasons to avoid cruelty to animals, not the least of which it is wrong for the animal itself, and also it is demeaning for people. With robots, I think it's clear that you wouldn't have it would be cruel to a robot, therefore for the robot's sake, we ought not to allow it. I do think there is some validity to the argument that allowing people to behave however they want to robots is demeaning to them and may encourage certain sorts of antisocial behaviors, whether, torturing a robot for fun is something that is, generally socially undesirable to see that sort of behavior out of a person. And so on that basis, I think, there is some validity to that argument, but I haven't thought about it much more than that.
Okay. You also note in the book that we've seen in the EU and some other places, countries flirting with the idea of granting the AI personhood or something equivalent. So just kind of, it seemed like some of those ideas kind of lost traction. Do you see anything else moving in that space?
I mean, it's definitely something people are speaking about, and speaking about more than they were previously. I don't think it's going to catch on in the EU anyway. There are some other jurisdictions that are a little more flexible about what they'll consider a person. And there have been some laws and cases, for example, Saudi Arabia saying that robot Sophia was a citizen, although it's not clear if they actually did that. It may have just been a publicity matter, or some cases out of Japan, and India has been pretty flexible on what they'll give some sort of legal personhood to. From my perspective, again, if we were to give a robot rights, it would only be because this somehow resulted in better outcomes from people, not because a robot deserves rights. And I can think of a few examples of where it might make sense to do that. But for any example I can think of, it seems better and easier and more efficient not to do it. So again, maybe an AI inventor could get a patent and assign the patent somehow to someone, but that just seems to create a whole lot of unnecessary complexity for no good reason. And it would just make more sense to have the AI's owner own its patents as an initial vesting. Or with self-driving cars, if you ever really had a non-commercial, totally autonomous self-driving car, maybe it needs to have its own insurance policy. But as a practical matter, it's hard to see how that sort of thing would come into existence. There's almost certainly someone who's going to be making a self-driving car for commercial benefit, and that's the party who should be liable for accidents it causes. So,
yeah. So I'm turning to some of the audience questions we have here, and again, we have a lot, to keep them coming. So one of the first questions I see here is, isn't the patent system an economic tool, not one premised on emotional impact? What evidence supports changing an economic tool to boost human creatorship?
Well, I think there's a variety of reasons that we give patents. In the Anglo-Saxon tradition, it is primarily an economic incentive. And no, that is my argument, that kind of regardless of a human inventor, what we're protecting is investment in AI, because this will encourage innovation and also promote disclosure of inventions and also promote commercialization of new products. And so for me, I think that really, if we do keep with this economic rationale, it supports protecting AI generated output. There are other reasons we provide patent protection. So for example, to protect the moral rights of inventors by listing them as inventors. But I think those arguments really don't apply where you don't have a traditional human inventor, or if they do apply, it is in fact that recognizing an AI as having invented, allows people to maintain their own sphere of inventorship without muddying that with people asking machines to solve problems for them.
Mm-hmm. I have a series of questions here around the question about, I guess, taxing robots. They say, should we extend this to the point that AI robots can become a protected class? Should we tax planes, trains, and automobiles? What about hearing aids, stents, pacemakers? Should all those be taxed as well?
Right. And it is for that reason that I am against a literal robot tax, for both the challenge of identifying, well, what should be taxed on what basis. No, you wouldn't make it a protected class, but even so, there's a lot of administrative cost with that. I think the better way to do it is just to have a neutral tax system between machines by eliminating taxes that are unique to people and by having a kind of broader, fair tax distribution between labor income and capital income. And so, for example, right, if you tax businesses a little bit more than we're taxing them now, and we get rid of payroll taxes, that would be effectively a robot tax, but you would not, be filling out W-2s for robots.
Question here on back to the AI inventorship. How do you see US, UK, and EU approaches to AI inventorship changing in the next 5 years?
A great question. Well, there's right now a very exciting international dialogue going on about these issues. I think that different countries will come down in different ways on it. So, for example, there are a couple EPO jurisdictions that don't require inventors to be natural persons. Israel doesn't require an inventor to be not an invention or a patent application. China has recently upheld or had a case upholding kind of copyright for what was allegedly an AI generated work, although there are some issues with that. But I do think in the next 5 years, some jurisdictions are going to realize that it is important to have laws that accommodate this, particularly jurisdictions that are seeking to be kind of AI leaders in the world. And that, when a jurisdiction like that changes, it may change very quickly. I do think in the next 5 years, some jurisdictions are going to allow patents on this, but certainly not all of them. And then it also does depend in part on national law. So in the UK, for example, our patent office rejection came with a nice paragraph at the end saying that the patent office really took no great position on whether this sort of thing should be protected. They were just applying the law as they interpreted it. But there needed to be a broader discussion about whether these sorts of things should be protected. And they're holding a call for views on this right now. In the high court case, it really came down to whether or not the word person was used in the Patents Act. And that kind of doesn't make sense because no one's questioning that back when this was written in the 70s, people weren't thinking about AI inventors, but the choice of word that they use then is dictating under current UK law whether or not this will get a patent. And I think the appropriate thing to do is to take a step back, decide what we want out of a patent system, decide what laws will be most efficient at getting it with respect to AI, and then to proceed on that basis rather than, well, or in the US, what do these statutes written in the 1950s say about, whomever versus, whatever.
Mm-hmm. Another question, a lot of questions on the inventorship. What are the ways a human might be able to contribute to an AI-generated invention and be eligible to be named an inventor? And they give some examples like, identifying things or training data.
Sure. Well, I think there's a lot of ways that might happen. And, part of the challenge of this is lacking clear definitions of things in these international discussions. So, I define an AI generated work as something without a traditional human inventor or, where an AI has functionally worked as an inventor. I think for the vast majority of AI being used in R&D, AI is just a tool, and it really isn't that hard to find a human inventor. And that could be someone programming an AI to solve a particular problem, someone training an AI in particular data, someone using an AI to solve a particular problem, or someone identifying an AI's output as inventive, because you can also qualify as an inventor by recognizing the inventive character of, a discovery, essentially. And so I think that really, if we decide to start getting into this, where is the boundary between AI and human inventorship, it really gets a bit murky. On the other hand, frankly, that sort of thing is already pretty murky right now as we go towards larger teams inventing things and multidisciplinary collaborations and who's an inventor versus who's a technician. And I think, frankly, we just need to take that body of law and apply it to contributions made by machines.
Mm-hmm. There's a question here. If an AI system commits a crime after you die, I guess you being the creator of that AI system, who is legally responsible?
Well, I think responsibility for an AI committing a crime has to date back, well, if it is a commercial product, that's one type of liability. If we're looking at criminal liability, I think it is largely based on the AI, on the developer's liability, depending on all the facts of the case. But let's say you trained an AI to go out and steal cryptocurrency from people's bank accounts. It is less what the AI has done and more what you have done, and we are focused on your actions and your mental states. And so if you died, well, we probably wouldn't hold you criminally liable for it, and you may have an AI that's going out committing crimes. But again, that is really based on reducible human criminal activity, and that's sort of an enforcement problem. Like, I've set a crime in motion and now I'm dead and we can't go after you.
There's a question here that came in. Are you proposing judging machines to the average human? Humans have high variability. Some of us are extremely careful drivers. I guess maybe can you just expand a little bit on the reasonable human standard and how you relate that back to the AI systems?
Sure. Well, I mean, this is a problem right now with people in tort law. I mean, to be clear, I think it is interesting. There are a lot of challenges with the law we apply now, and AI entering the picture kind of is an opportunity for us to take a step back and consider some of the ways we've been doing things. But generally in tort law, we say, well, would a reasonable person have caused an accident? And, in practice, that more or less maybe a juror thinking, well, how would I have driven? And yes, you have some very safe drivers and you have some very bad drivers. But as a general matter, we hold everyone to this hypothetically constructed average person. And yes, the average person doesn't really exist. And yes, the average person is really kind of variable in the mind of the person applying the test. And that's a bit of a problem. But it's hard to come up, or it has been hard to come up with a better solution to that. If you're a safer driver, you get to enjoy the fruits of that by hopefully causing fewer accidents and being held to a lower standard. And if you're a worse than average driver, that's just sort of too bad for you. We don't give you a break on that. Well, pretty soon we are all going to be bad drivers compared to AI. And, I think that's probably a good reason not to do as much driving. But, that we should have the right to do so if we choose.
Yeah. So I think we have time for one last question, and I want to relate it to kind of a few that came in, basically just around the issue of China. And, we're seeing China, of course, be a major player in AI. How will Chinese potential dominance in this field affect some of these, issues that you raised in the book?
I think that the legal frameworks that countries adopt to regulate AI is going to be a critical factor in their industrial development. And, this being one factor of it, China, for example, has, very different values along things like privacy and data ownership and automated decision making. And, some of these, reasonable people could differ about what underlying values should be guiding it, but for some things like, the laws that I'm proposing that I think makes the law function better for everyone, I do think that adopting AI appropriate and AI centric laws will help with industrial development. And, there's often a concern that regulation is going to interfere with or cripple AI development. And I think that really misses the point, because I think that AI is already regulated plenty. It's just regulated by laws that weren't designed to regulate AI. And sometimes that just kind of doesn't make a lot of sense. And we need to take a step back, see that factually things are happening in different ways, and think about, well, how should the law change to make sure we get as much social benefit as we can?
Yeah. Well, Ryan, I think we'll end there. Thanks again for your presentation today and going through these questions. Again, I highly recommend your book to everyone who's watching. The Reasonable Robot, Artificial Intelligence in the Law. It's a great read, great conversation. Thanks again for being here today, and thanks to everyone for participating.
Well, thanks so much for having me. It was a real pleasure, and look forward to speaking soon.
Thanks.